Your dismissed arrest could still be costing you.
Imagine being arrested for something you didn't do, and even after the case falls apart, that arrest clings to your record like a permanent stain. What if you could legally erase that arrest, as if it never existed? Today, we're breaking down one of the most powerful tools in California law, a motion for factual innocence under Penal Code Section 851.8. When used correctly, it doesn't just hide your arrest record, it can force the government to seal and destroy it entirely. If you were wrongfully accused, this may be the most important legal remedy you have. Picture this, you're leaving work in Oakland when officers approach you. They say you match the description of a burglary suspect. You're handcuffed, booked, and held for hours while your family panics. Days later, the district attorney declines to file charges because surveillance video proves the suspect wasn't you. The problem? That arrest still shows up. Even though you did nothing wrong, the system leaves you with the burden of explaining an arrest that should have never happened. California recognizes how deeply unfair that is. That's why Penal Code 851.8 exists, to restore your name, your record, and your future when the system gets it wrong. A motion for factual innocence is a specialized legal remedy for people who were factually innocent at the time of the arrest. Under this section, you must prove that law enforcement had no reasonable cause to believe you committed the offense and arrest you. This is a higher standard than simply showing a lack of evidence. It requires demonstrating that the arrest itself was unsupported by objective facts. People often confuse this relief with the petition to dismiss process, but they're not the same thing. A petition to dismiss, which people typically apply the misnomer of an expungement, is available after a conviction. It allows you to withdraw a guilty plea and have the case dismissed, but the conviction itself still exists in history. A motion for factual innocence is different. It's not about forgiveness or moving past a mistake. It's about declaring that there was never a mistake on your part at all. It is the cleanest slate California law offers. This motion is available whether you were arrested but never charged, charges were filed but later dismissed, or you were acquitted at trial and want your arrest record eliminated. But here's the key. The burden is entirely on you. Unlike most criminal proceedings, where the government must prove guilt, this is one of the rare situations where you must affirmatively meet the burden of proof. Courts look for strong, credible evidence such as surveillance footage proving you weren't there, witness statements confirming an alibi, evidence of mistaken identity, contradictions in police reports, or physical evidence excluding you from the crime. When the judge grants the motion, the court orders your arrest record sealed and destroyed, and all agencies must treat the arrest as if it never occurred. Factual innocence motions are powerful, but they're also often misunderstood. A case dismissal alone is not enough. California dismisses cases for many reasons, and none of those automatically establish factual innocence. Timing also matters. You generally have 2 years from the date of the arrest to file with the law enforcement agency, and if denied, you can petition the court. Late filings may be allowed with good cause. Police departments rarely grant these petitions voluntarily, although it is possible, and our firm has obtained grants from law enforcement directly, but even when the evidence is overwhelmingly in your favor, agencies tend to deny them, which means the real fight often happens in court. Judges treat these motions seriously because they involve the extraordinary step of erasing an arrest from state records. You must present compelling, well-organized evidence showing the arrest should never have occurred. But when done correctly, this motion gives people their lives back. It prevents outdated or inaccurate arrest information from being used against you by prosecutors, employers, licensing boards, and background check companies. If you're pursuing a motion for factual innocence, there are 5 strategies that consistently lead to success. First, build a clean, organized evidentiary record. Collect every piece of evidence proving you weren't involved: alibi statements, phone data, receipts, GPS data, and surveillance footage. Objective proof is essential. Second, attack the basis for reasonable cause. We scrutinize the facts officers relied upon. If the arrest was based on faulty assumptions, unreliable witnesses, or misidentification, we highlight those failures clearly. Third, use expert testimony when needed. In cases involving forensics, digital evidence, or mistaken identity, expert analysis can decisively show why the officer's conclusions were incorrect. Fourth, demonstrate prejudice from the arrest record. Judges are more likely to grant relief when there's evidence the arrest is actively harming your employment, professional licensing, or other opportunities. Finally, present a compelling narrative of innocence. This motion requires clarity, discipline, and precision. We weave the facts and evidence into a clear, authoritative explanation showing the arrest never should have occurred. When these strategies come together, they create a persuasive presentation that gives the judge confidence to grant the motion. If a wrongful arrest remains on your record, the consequences can follow you for years. With a successful order, agencies must treat the arrest as if it never occurred. No disclosure. No explanation. No shadow over your future. If you were wrongfully accused in California, you deserve a clean slate, and the law gives you the right to fight for it. A motion for factual innocence can restore your reputation, protect your opportunities, and remove an arrest that never should have happened. This process is complex and evidence-driven. You shouldn't navigate it alone. If you think you may qualify for a motion for factual innocence, the time to act is now. Schedule a consultation today to talk about your case and explore how you can finally put this arrest behind you and move forward with confidence. Call our office. We're ready to fight for your name, your record, and your future. Finally, if you found this video helpful and you want to stay informed about your rights, California criminal law, and the strategies that can protect your future, make sure you like this video, subscribe to our channel, and turn on notifications. We publish powerful, practical legal content every single week to help you stay prepared, stay informed, and stay in control. Your support helps us reach more people who need this information. So hit that like button and subscribe today.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.